Hi, Assalamualaikum. My name is Nurhani Fatma binti Muhammad Zaid. As part of this assignment, we will examine the specific provisions of the Local Government Act 1976. Parties have the right to make objections and their rights are examined as well as opinion may be lodged based on valid reasons, procedures and rules handling objection proceedings by government agencies. First, I will outline the judicial review initiated by Tenaga Nasional Berhad (TNB) against the Segamat District Council decision regarding assessment rates on transmission towers. TNB contested the Council's decision in meetings held on March 14, 2017 and April 12, 2017, seeking a writ of certiorari to annul the decision and recover costs. They argued the lack of proprietary interest in the land where towers stood, asserting only wayleaf right under the Electricity Supply Act 1990. The Segamat District Council countered that towers were accessible structures, thus subject to assessment rates, but they did not provide the exact location of the towers, making it difficult for TNB to ascertain which property were subject to assessment rates. Now I'd like to discuss the provision in Local Government Act 1976 to allow the interested party to make an objection. Under Section 142 of the Act, any person aggrieved by a valuation list may lodge objections based on grounds such as incorrect valuation or omission. This objection must be submitted in writing to the local authority at least 14 days before the valuation list revisions. Section 144 allows the valuation officer to amend the list due to error or change in property value, requiring notice to all interested parties. Individual can object in writing within 10 days of the notice. Should a disagreement persist, Section 145 grants the right to appeal the High Court through an originating motion. This appeal must be filed within 14 days of the local authority decision. With the High Court's final ruling on functional matters, legal question may be further appealed to the Supreme Court. This provision ensures a fair and transparent process for property owner and interested parties, maintaining accountability and legality in property assessment and taxation.
Hi, Assalamualaikum. My name is Yasmin Ismira and my matrix number is 2023165319. So for today, I will explain about the provisions in respective law to allow the interested parties to make an objection. First, under the Local Government Act 1976, interested parties have specific provision that allow them to make objections regarding valuation decision. Here is the detailed explanation of the process. In Section 142, this section allows individuals to challenge the assessment list if they believe it is incorrect, inflated, or lacks necessary details. If a person feels that their holding is valued beyond its rateable value, not really relatable or omitted from the valuation list, they can raise objections in writing to the local authority. Next is Section 144, which is the valuation officer is empowered under this section to make amendments to the valuation list at any time. If individual believe they have been treated unfairly due to amendment, they can submit formal objections in writing to the formal local authority based on the grounds specific in Section 142. And also under Section 145, in case an individual disagrees with the decision made by the local authority on their objection, they have the right to appeal to the High Court by filing a petition known as originating motion. However, it is a requirement that the disputed rate amount must be paid to the local authority upon filing the appeal. Now we explain about the right of interested parties to make an objection based on the provision of law allowed them. So, under Section 137 of Act 171, this section allows individuals to oppose any modification made to the valuation list. If there are errors in the evaluation of a holding, such as omitting it from the list or undervaluing it, individual have the right to file complaints. Then, under Section 144 of Act 171, under this section, the valuation officer is empowered to make changes to the valuation list for various reasons, including errors, oversight, or fraud. If individuals believe they have been unfairly treated due to amendments in the valuation list, they can raise objections within a specific time frame. And lastly, Section 145 of Act 171, in the event that individuals are dissatisfied with the decision made by the local authority on their objections, they have the right to challenge it by filing a petition known as an originating motion in the High Court. It is a requirement that the contested rate amount must be paid to the local authority upon filing the appeal.
My name is Muhammad Ashraf Moimin. There are 7 procedures to make an objection. First is ground for objection. Objection can be made if the holding is valued below its rateable value, is not rateable, have been removed from the valuation list, is value over its rateable value, or if the valuation is inaccurate. Second is written objection. The objection must be submitted in writing to the local authority at least 14 days before the scheduled date of the valuation list amended. Third is opportunity to be heard. When the objection are under inquiry, the person submitted the objection must be given the chance to be heard in person. Fourth is notice of amendment. Any interested parties must be notified of any changes to the valuation list and given at least 30 days notice from the date the notification is served to the date amendment is to be made. Fifth, if objection to amended, any person aggrieved by the amendment of the valuation list have 10 days to object in written to the local authority before the period stated in the notice. 6. Commission of amended. Any amendment made in the valuation list must be approved by the local authority. Lastly, if the aggrieved person is unsatisfied with the local authority judgment on the objection, they may appeal to the High Court through organization motion. The organization motion must be submitted within 14 days of the revising the judgment, and the amount of the rate appeal against must be paid to the local authority. There are 3 rules and functions of respective agency in an objection proceeding. First is local authority. The objection procedure is managed by the local authority. They receive written objection from aggrieved parties, assess this objection, and give an opportunity for the objectors to be heard in person. Second is valuation officer. The valuation officer has the right to change the valuation list at any moment for many types of reasons, including errors, oversight, fraud, and change in the value of asset. Third is High Court. Anyone who is unsatisfied with the local authorities' judgment on an objection may appeal to the High Court.
Assalamualaikum. My name is Muhammad Zarif. Very good day. So today I will be explaining about the answer of second question, that is question 2. So for the Local Government Act 1976, Act 171 outlines the responsibilities of the powers of local authorities in Peninsular Malaysia. Local authorities face several issues and challenges in administering urban services. So one major challenge that we can see is funding and also resources, as limited financial resources can hamper their ability to provide adequate services. For revenue from taxes and other resources may not be sufficient to meet the demand of urbanization. Secondly, we can see that rapid urbanization leads to increased demands for services such as waste management, water supply, infrastructure maintenance, and also putting pressure on local authorities. Human resources are another concern, with a shortage of skilled personnel needed to manage and implement various functions effectively. Regulatory compliance is also complex and resource intensive, so they are requiring significant effort to ensure adherence to numerous regulation and also standards. Furthermore, local authorities, we can see that local authorities must often coordinate with state and also federal government, which can lead to bureaucratic delays and also conflicts. And lastly, that we can see growing public expectations for high quality services, of course, to add another pressure on local authorities to perform efficiently. So as we can see, while Act 171 provides legal framework, addressing these challenges requires effective governance and also strategic planning and also adequate resource allocation.
So, for the conclusion, local government in Venezuela, Malaysia face many significant challenges that require a multifaceted and collaborative approach by improving financial management, streamlining administrative process, encouraging public participation, and also promoting sustainable development and updating legal framework. Local government can enhance service delivery and support sustainable inclusive growth, which is emphasizing innovation, transparency, and community engagement is essential for overcoming this challenge and ensuring the well-being and prosperity of urban residents. That's all from us, and thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aman Wabirahim. So for the procedural irregularities, objection can be made if the SDC did not follow proper procedures, such as failing to provide adequate notice to TMB or not allowing TMB a fair chance to present objection, unreasonable or irrationality. Assessment rates can be challenged if they are disproportionately high compared to similar properties without clear justification. If TMB property is assessed higher than comparable properties without a valid reason, this disparity can be challenged. Illegality arises when the SDC acts beyond its legal power or misinterprets the law. If the rates imposed are not authorized by relevant statutory provision, TMB could argue that the SDC decision was illegal. Failure to consider important factors. The SDC must consider relevant factors such as property use, value, economics condition, and comparable rates. Ignoring this factor or considering irrelevant one can result in flawed decision, bias, or conflict of interest. Any evidence or bias or conflict of interest among SDC members can undermine the decision integrity if members had personal interest influencing the decision or showed the favoritism. Assessment rates could be challenged. Applicant to TMB versus Segamat District Council. In this case, TMB sought a judicial review of the SDC decision. TMB might argue procedural failures, unreasonably high rates without justification, illegal imposition of rates, and the failure to consider relevant factors. Any bias or conflict of the interest would further support TMB's objection.
So, for the conclusion, local government in Venezuela, Malaysia face many significant challenges that require a multifaceted and collaborative approach by improving financial management, streamlining administrative process, encouraging public participation, and also promoting sustainable development and updating legal framework. Local government can enhance service delivery and support sustainable inclusive growth, which is emphasizing innovation, transparency, and community engagement is essential for overcoming this challenge and ensuring the well-being and prosperity of urban residents. That's all from us, and thank you.